Good evening, everyone. I hope you are all doing well. Thank you for attending tonight's interview, and thank you to our loyal attendees who attend every other interview and webinar, every other event we do. Tonight, as every other event, we have a very special guest. Tonight's guest, it's Urs Stirnimann.
Good.
Thank you. I tried my best. Urs is a Swiss legal expert with over 25 years of international experience across Middle East, Latin America. But apart from that, Urs' relevance to the interview dedicated to the laws of war and to the conflicts around the world and in our region, specifically Lebanon mostly, is Urs' work with the ICRC, International Committee of the Red Cross. He was stationed in conflict zones such as Sur in Lebanon during the civil war times and the Israeli occupation in the 1980s. He visited the prisoners at Ansar camp in South Lebanon. He provided the humanitarian aid. He delivered presentations on international humanitarian law at Geneva Conventions, which are the foundation of international humanitarian law. So we like to welcome Urs. Urs, if you'd like to say anything more about yourself before we dive deeper into tonight's interview.
Well, thank you, Issam, for the kind introduction. It's a great pleasure for me to go back to my old times, to the times and to think of Lebanon, where I have spent 2 years in 1984-85, when I was stationed in Tyre in Sur, in the south of Lebanon, working for the International Committee of the Red Cross. Now for 20 years, I'm here in Dubai, where I had a large law firm, and I was a banker also for quite a while. But I was always very much involved in international humanitarian law, Geneva Conventions, and for the last 30 years, I gave regularly courses about this law, international humanitarian law, the laws which are applicable in time of war or armed conflicts. And therefore, I was very pleased when I was approached by you, Issam and Antoine, whether I could give you some information about it. And therefore, it's quite a pleasure for me to give a presentation. And I do hope of all of you that you interrupt me all the time, that you have questions. So feel free to ask anything you want to know. And I will try my best to be able to give you some answers. Okay, and with that, is that okay if I share my presentation? Let's see if I'm able to do that. Okay, so I will speak about IHL, International Humanitarian Law, and about what it is, the origins of it, the essential rules, use at bellum, use in bello, the Geneva Conventions, and the protocols. So the international humanitarian law is part of the public international law. I assume that most of the participants here tonight are lawyers or are coming from the legal
They're
profession.
all from legal background and legal profession.
Okay, so of course you know about public international law. Perhaps you also had a little bit a view into the law of armed conflict, the law of war, about the Geneva Convention a bit. And tonight we remind you a little bit about it here. This is a drawing when I was stationed in 2002 to 2004 in Al-Khalil, Palestine, when I was a diplomat there for the Swiss government, overlooking the situation in the Ibrahimi Mosque, where Abraham and his family was buried 3,000 years ago. Well, what is this IHL? It comprises the rules applicable in time of armed conflict. It's to protect people who are not longer taking part in hostilities. So it's not about the soldiers, but it's about those who are not participating anymore in the armed conflict. That is then discussed, and some rules were issued how they should be protected. So it restricts the methods and means of warfare employed. And there are international treaties or customary law international treaties like the Geneva Convention or customary law, which became law through customary usage over many decades or centuries of use. And they are to resolve humanitarian issues arising from armed conflict. They are either international or of non-international nature. International conflicts between countries, between country A and country B, and non-international inside a country. If there's a civil war, that is covered by it. And internal disturbances, internal tensions, that's not really part of it. So it restricts the right of the parties to what kind of methods and means of war that they can choose, and it gives a general protection to people and property affected. So this goes back to the law of Geneva. It is to safeguard military personnel who are no longer taking part in the fighting. So those who are out of fighting because they're wounded, they are in hospital, or they have surrendered, so they cannot be attacked anymore. And of course, civilians, they should be protected all the time. And there's also the law of the Hague of the Netherlands, which was also in force for about 150 years. And this established the rights and obligations of those who are fighting in the conduct of military operations, limits the means of harming the enemy. So what kind of weapons, how can they be used? That is described in the law of the Hague. One thing is important, which I want to mention, is Hugo Grotius. Hugo Grotius is a Dutch guy. He lived about 500 years ago, and he is also considered the father of international law. And he said something very important, that it's not useful to distinguish between just wars and unjust wars. So if you look at the rules which should be applied in a conflict, in an armed conflict, it doesn't make sense too much to distinguish and say this is a just war for this side, and for the other side it's an unjust war. Let's, for example, look at the situation when we look at the occupation when the Americans went into Iraq. They considered that from their side quite a bit as a just war, and they used all kind of torture and all kind of things, and treated people quite badly, saying, well, we do that because we're on the right side, and that gives us the right to really try to get all kind of information out of persons, and that we also can use torture for it. Therefore, Hugo Grotius already 500 years ago said it's not of any use to make a distinction between just wars and unjust wars. If you look at the rules which should be applicable in an armed conflict, then we just look that those rules are applied, and not whether one side is on the right side and therefore they are able to use it more tough, the application of these weapons and arms and warfare, than the other side. So this is, I think, is a very important thing. And if we go back a little bit in history, that of course we have all kind of people who wrote about it. And then one person I would like to mention, because especially also in your country, the Red Cross movement is quite strong, be it through the Lebanese Red Cross, which is very, very beneficial for the last decades, helping all the bodies, and also the International Committee of the Red Cross, the League of the Red Cross organization, and all those. That goes back to Henry Dunant, who 150 years ago wrote a book, A Memory of Solferino, where he described and said how people should be treated, that soldiers who are not able to fight anymore, that they should be assistance should be given. And he was instrumental that in 1864, the diplomatic conference in Geneva was organized, where the first Geneva Convention was established. And in the first Geneva Convention, it was also already clearly said we should always distinguish between civilian population and combatants. And no attacks can be made against civilians as a whole, nor against individuals. This is what's written in the Geneva Conventions, and attacks can only made against military objectives, against weapons, about casernes where the military, the soldiers are living. Attacks can be made against them, against checkpoints, and so on. That is possible. But it's not allowed to attack those who have surrendered, who no longer participate in the fighting. They cannot be attacked. And it's also forbidden to use weapons or methods of warfare that are likely to cause unnecessary losses or excessive suffering. So only weapons should be used which only really attack the armed person on the other side, but not the civilian population. You shouldn't be using big bombs, which perhaps are aimed at one soldier, but afterwards killing 500 civilians. That, of course, shouldn't be done. It also says that the wounded and sick person should be collected and cared for, and that this should be done for anybody. It shouldn't be distinction, okay, we only collect and look for those which are on our side, and that the medical personnel, the establishments, the hospitals, that must be spared, and that they shouldn't be attacked. So all this is written in those Geneva Convention. Then also it was quite important to see how can we distinguish between persons who are still fighting and those who are giving assistance, medical assistance to such persons. And since the idea came from Henri Dunant from Geneva, from Switzerland, it was proposed to say, okay, we use the sign of Switzerland, but with the colors inverse. So it is a red cross on a white background, since Switzerland has a white cross on a red background. So the red cross then became the sign of protection for the nurses and medical assistants in times of war. This was all fine for the first 20, 30 years, but then there was a war about the Crimea between the Ottomans and the Russians. And it was, of course, difficult for the Ottomans, Muslims, to say, okay, as a protection for our medical personnel, we should use a cross, a red cross, the sign of the Crusaders. They said, of course, that is absolutely impossible. There was then introduced the Red Crescent. And for about 30 years now, it's also the red crystal, which is introduced as a sign of protection. For a while, also the red lion and sun was used by the Persians, by Iran, until there they had the revolution in 1979, when Khomeini came in, and then they then said, okay, we will use also the red crescent and not anymore the red lion and sun. So the red lion and sun is not used anymore. And of course, captured combatants, prisoners of war, and civilians are entitled to respect for life, and all in anywhere the principle of proportionality applies. This is now also very often now in discussion when certain attack happens, and then they say, hey, this is absolutely not proportional. For example, if there's a stadium and in that stadium you have perhaps 10, 50 soldiers and it is attacked, but the soldiers are within a community of 500, 1,000, or 10,000 civilian, that definitely would not be proportional. That definitely would be against the law. Yeah.
Hi, sorry to interrupt you. So if I would pause on take a pause to where you reached right now in the presentation and the explanation, and given your experience in Lebanon during the times of war and during the times of conflict, and I'm quite certain that you witnessed there was no proportionality in the aggression, or even nowadays, wherever conflicts are, there's the principle of proportionality is not well respected. what can you share from your experience and what you witnessed and your work with the ICRC during the times of the civil war and the Israeli occupation in Lebanon, and how was the condition of the prisoners in Sar and in Sur?
Okay, what I in general can say, of course, I have mentioned a lot of principles of protection and so on. And of course, as with any laws, there are always violations of laws. I'm having been driving with the car today, and I'm sure I've violated several laws today on the street. And a similar thing happens in war. But of course, in war, it's more dramatical because people die, are hurt. And of course, that's completely different. And what I also see in all the wars, there are war crimes. And later on, we will discuss and see what are really war crimes. They usually happen on both sides. It's not that you can say, okay, there's an armed conflict and all the violations only take place on one side and the other side doesn't have any violations. So that was never my experience. And if I look back in the different places I were, whether I was in the Middle East, whether I was in Latin America, always on both sides, things happen. And of course, each side would like to have the support from the International Committee of the Red Cross, of the international community, saying, hey, please tell them that we are on the correct side and the others are on the wrong side. And this goes now back to what Hugo Grotius said, who said, in such a situation, for those organizations like the Red Cross, they are not there on the blaming side. They don't go out and say, hey, this side is correct, this one is not correct.
Okay.
This is quite a different side than, for example, Amnesty International. Amnesty International goes publicly out and says, hey, these are violations from this side or the other. Yeah.
Definitely, Amnesty International take more of a proactive role in this case. So if I were to put that aside and speak more internally, you mentioned something that international humanitarian law or the laws of war in general do not apply for internal tension or internal tension or conflicts. And
No.
yes,
I said internal tension, but it is internal armed conflict. It applies. There applies certain rules, not all of them. So in a civil war, not all of the rules apply. That's in the Geneva Convention, it's only Article 3 and the Protocol number 2. These apply.
So,
yeah.
Let me ask you something to follow up on what you said, that both parties do have violations of international humanitarian law. Both parties do violate the laws of war and the principles, which and every party tends to want the support of the international community and the international organizations. However, when tackling war crimes and when we discuss the phase of accountability and trial, do we take each crime by itself, or do we tend to assess the whole war as one act, as one phase? What do you think? Should we take each crime, each event as a separate war crime, or do we discuss the whole war as one phase, continuous?
No, usually then you should look at each individual thing. For example, when I was stationed in the West Bank with the International DIPH organization, we daily wrote articles or reports to both sides, to the Israeli occupying force and the Palestinians, pointing out things which we saw were violating the international agreements, the Geneva Conventions, and were certain things which were also clearly pointed out as war crimes. And then it is up to the party who makes the war crime to act and prevent it. And if this is not the case, then all the countries which are part of the Geneva Convention, that is more or less all the countries are worldwide, are part of the Geneva Conventions, that they should react. So if somebody in Latin America or in Belgium or so is aware of that somebody was involved in a war crime, and is aware that this person in its own country was not apprehended, was not questions concerning it, then it's up to all countries to ask the person, hey, what did you do? And even start a tribunal against him.
Urs, since you mentioned the reports and the articles you used to write, and probably we have a question from attorney Ahmed Al-Naggar, in which he asks, is it easy to find historical reports for violations that maybe were recorded by the Red Cross, or is it difficult to find? Is it easy
No,
to
the
find
International
public?
Committee of the Red Cross has quite a large website with a lot of reports. They also write a monthly or bi-monthly magazine where they report about all these different situations they have. They don't go into the details, that is clear. They will not go into detail and say, in the civil war, for example, of El Salvador, saying, okay, the guerrilla made these violations or the government made these violations. They will not go that directly into it, but they gave a certain overview so that you can understand the situation.
But we might find like an archive for reports that date years back to violations.
No, those reports which are given to the countries, they will not be opened. No. The International Committee of the Red Cross will not do that, but you can go with the UN, and there certain things are open which you can check it up in the archive.
So all reports that are directed directly towards the government are kept confidential. They cannot be publicly shared.
Yeah. Only in very, very exceptional situations where they see, well, we don't have access at all, it doesn't work at all, then they will go very cautiously publicly about it. Yeah.
Okay. Now for the next part of our discussion, to follow up on the questions, would you like to discuss war crimes or would you like to discuss?
Well, if I perhaps quickly can go through these things here, because I will bring up after, since you are lawyers, I will bring up certain articles which you should be aware of.
Okay.
So that you really can use them. So here we have the jus ad bellum, and which addresses the suffering without considering the reason. Jus in bello, the law in war. It's difficult to determine which state is guilty. So the International Committee of the Red Cross doesn't enter this at all. And protection is given without considering any guilt on one side or the other. And we should also not forget, until the end of the First World War, resorting to armed force was just normal. This was not illegal at that time. It was always, okay, if we don't have any success diplomatically, well, then we go to war. Then after the First World War, the League of Nations started, where they tried to outlaw wars. It was which was not very successful. And then after the Second World War, the United Nations came up, the successor of the League of Nations, where they said war is forbidden, only self-defense is allowed. This is also then the reason that these days nobody speaks anymore of war. When the Americans went into Vietnam, they were not speaking of we are doing a war there, because by saying we do a war, we make a war, you're automatically violating the United Nations Charter. So they went in there and said, we assist the South Vietnamese. And that's usually a reason to do it. Always the people do it for defense. Before the Second World War, there were ministers of war. These have disappeared. Now they're called Ministry of Defense. And these days, it's,
I would like to follow up on this thought second. So countries and governments who engage in armed conflicts will definitely not tend to call them wars, because it's an explicit confession for the violation of international humanitarian law. However, as in basic criminal law, it's not up to the perpetrator to qualify their act, if it qualifies a crime or not. So who is able to determine if this certain act qualifies as an initiation to war, or is it an act of self-defense? And do we take, as I asked before, the event itself, or do we accumulate the series of events which lead to the armed conflict, which could be raised by the United States or any other party, any militia group?
Well, there's usually, if there's no court looking at it, then there's no real decision about it. No, so the Americans went in and their supporters went into Iraq, there was not a tribunal looking at it afterwards and say, okay, who is right, who is wrong, who made violations, and so it just disappears. Now it's different with the situation in Palestine and Israel, that this is now in the International Court in The Hague and also in the International Criminal Court. There they are looking at it, but that will take also years. Here, perhaps also, if I may say something,
Yes.
after the Second World War, more or less it was more or less considered illegal to have colonies, and the colonies disappeared. And there it was also given the right that colonies, those countries, that they have the right to self-determination and that they can defend themselves or attack their suppressors. So only states become party to international treaties. However, all parties to an armed conflict are bound by the international humanitarian law. And as I mentioned before, almost all states of the world are party to Geneva Conventions. For example, here, 196 states signed it, are part of it. And in the United Nations, we have, how many nations we have in the United Nations? 193. There were even less countries in the United Nations there, and then there are with the Geneva Conventions. Then we have also afterwards in the 60s, the additional protocols came out. Protocol 1, which gives additional assistance during international armed conflict. Protocol 2, which gives assistance during internal armed conflict. So usually how this is applied, okay, and then that the country should distribute and that the International Committee of the Red Cross should look for dissemination like we do now tonight. We give a little bit of dissemination about these Geneva Convention to make yourself a bit aware of it. And the first Geneva Convention is for the people, for the soldiers in armed conflicts on land. And the second one is on sea for sailors. And then after the First World War, we had the protection for the wounded, not the wounded, but for, let me see, are we going for prisoners of war? Is it? So the prisoners of war were then protected only after the First World War. So there we had a lot of rules coming out for prisoners of war. But what is more important perhaps for us here is to perhaps also spies and mercenaries are not entitled to the status of prisoners of war. So mercenaries are considered just normal criminals and can then be considered according to the criminal law of that country. So they don't fall under the protection of the Third Geneva Convention. So prisoners of war, then also we need to give very limited information. A mercenary is not, doesn't fall into this category. They have to give more information. I mean, they're normal criminals and looked at it as that. Okay, then what is also quite important is that such prisoners of war, that they should be repatriated without delay at the end of the war. And there's a central tracing agency, the ICRC, which helps finding people if they have disappeared. And there are over 50 million cards which were written by people who are looking for their family members.
Urs, I just had a question that popped in my mind.
Yeah.
So when you mentioned the spies and that they're not treated as war prisoners, okay?
Yeah.
And if we recall the Geneva Conventions, also combatants who are not combating or individuals who are not combating at the moment are protected. They're protected under the conventions. If the army or the armed forces or the armed groups do take combatants who are not in the line of action at the moment of imprisonment or capturing, do they qualify as war prisoners or do they qualify as spies? What's their qualification? Are they protected in this case?
I mean, you say soldiers which are not participating in the conflict, or what?
Soldiers which are not participating at the moment. If we know that under international humanitarian law, if a soldier is not present in the field of battle at the moment, he is protected under international law. So in this case, any violation to these against these individuals or any attack against these individuals should qualify to a war crime, or is it a case-by-case analysis?
Yeah, that is quite a critical thing, which also came up very often in Israel discussions when they were attacked against soldiers, or perhaps over the weekend when they were at home. And there are different opinions concerning it. But in any case, they should be treated. I mean, if you would attack such a person, of course, perhaps the attack can be done against the soldier, but it shouldn't be attack against the whole family. Or perhaps if you make a suicide attack against one soldier which is perhaps not participating in the war, then of course you cannot attack at the same time a whole bus with civilians on it. So that would be against the proportionality rule, and it would be considered a violation, or it would be considered an attack at civilian population. Then prisoners of war who are detained, they also have the right to be visited by the International Committee of the Red Cross, like what I did when I was in Lebanon 84, 85. We visited the prisoners, the detainees, the internees, you could also call them. There were also many civilians interned there in Ansar near Nabatieh. When I was there were about 5,000 people interned them, which we visited regularly to see whether how they are treated, that they got enough food, that they got medical assistance, and that they are that they are treated according to the Geneva Conventions. And then detainees who have also the right to write letters, like we see here. They can write letters. They are censorized then by the detaining force, and they're given to the International Committee of the Red Cross. Then we were traveling all over Lebanon to hand them over to the families. The families then wrote responding replies, small letters, which then were censorized again by they were read and, if necessary, censorized by the Israelis, and then they were given to the detainees. So that is quite an important thing to do. Then to the HAQQ Convention, they came out in 1907. They gave a general protection to civilian population against the people, and it's against prohibit use of weapons. That material methods of warfare cannot cause unnecessary injury, otherwise it would not be allowed. And then it also says that any person not belonging to the armed forces is considered a civilian. And civilian property is anything which is not a military objective. These days, it's also quite a difficult thing because countries or towns have become bigger. Usually the casernes where the soldiers are living were usually outside of towns. But since the towns expanded, very often now the casernes where the soldiers are living are in the middle of a town. So that makes it quite difficult then to distinguish, is this now an attack against a military objective, or is it when many civilians are injured or killed as well? Is it a clear violation and considered an attack against civilians? And then the movements of civilians must not be used to try to shield military objectives from an attack. So the military people cannot hide, as I mentioned before, they cannot hide in a stadium, for example, which was mentioned, or in such situations. That shouldn't be done. That will be, and starving of civilians is clearly forbidden. And foodstuff, agricultural areas must be given, of course, to the people all the time. Otherwise, that clearly would be a violation of the Geneva Conventions.
Urs?
Yeah.
Excuse me to interrupt again. And
no, please always interrupt. That's good.
But I think myself, like the attendees and myself, would like to know, in addition to the great explanation and presentation about international humanitarian law, much more about your involvement with the International Committee and the International Committee itself. We have a question here on how can lawyers participate in the efforts of the Red Cross worldwide, and what are the ways that we can apply as lawyers, as legal practitioners, and get more involved if we wish to in the practice and in the work of the International Committee and the Red Cross in general to help in the humanitarian.
Okay, that's a very good question. That is definitely in need. The International Committee of the Red Cross always needs delegates. In the past, when I was a delegate, usually they only took Swiss people as delegates, but since the Red Cross has become bigger, the International Committee of the Red Cross, delegates can now come from all kinds of countries. So Lebanese, who have many languages, of course, speaking Arabic, English, French, and perhaps other languages as well, are very much welcome. So the best way is if you go to the website of the ICRC.org or .com and check. Usually they have some application forms. And usually perhaps you should also visit the ICRC offices, which are in Beirut. And I assume there are also in Saida and in Tyre, in Sur. Visit their office and ask them. Sometimes perhaps not so helpful in assisting you to find a job there. But nevertheless, that you go and find it in the website, then you apply. Usually, when you want to be a delegate, you will not be accepted as a delegate in your own country because you should be neutral, you should be of a certain independence. And of course, if you see in Lebanon how badly the country is treated, it's of course very difficult for you to say, hey, I'm completely neutral. This doesn't matter to me. For me as a Swiss, this is of course completely different. I say, okay, I'm here for 1 or 2 years, then I'm moving out to a next country, but that gives you the opportunity then perhaps to be stationed one day in Africa, in Latin America, in Ukraine, Russia situations, and so on. So these are definitely possibilities. And as a lawyer, if you have a certain understanding of the Geneva Conventions, and if you can show you have certain understanding, then it definitely helps you already to find a job. Very often also, if people who start working with the International Committee of the Red Cross, subsequently they try and work for some UN operations, and then they perhaps have a job for the whole life. Yeah.
Urs, I have 2 questions in mind, one of which is more personal and the other is a bit general about what you said, but I will follow up first on what you said, that delegates should not work in their own countries to ensure neutrality and impartiality. So let's assume a delegate is deemed not be acting neutral by the International Committee. How would they assess if the actions or the reports or the decisions made by the delegate are dealt with in a neutral manner, in an impartial manner, and what are the consequences for not acting in a neutral way?
Well, for example,
like
certain risk can be when I was, for example, in Lebanon, we were always driving around from bringing the family letters to those letters to the families or to the Ansar. And then very often we were stopped on the road and people asked us, hey, can you help us in just acting kind of as a taxi, which we, of course, cannot accept because you never know whether perhaps one of these persons you take in your car perhaps is with one of the armed groups. And then if the occupying force sees you driving around some people, which they clearly can identify, hey, this is a person of an armed opposition force, then of course the Red Cross would lose all the impartiality and neutrality and would lose the image. So therefore, for a foreigner, it's easier for me a lot easier to say no than for you in Lebanon to say no to your partners of your own country now.
Definitely. I will not ask you how you ended up in Lebanon because the simple answer would be as a delegate for the International Committee. So my question to you is more of how did you get involved with the International Committee? Why did you decide to join as a delegate? How was it dealt with in the first place? Was it something out of faith in humanitarian law, or did it happen all by coincidence? how did you become involved in the humanitarian law and international
Well,
law?
I studied law at the university in Zurich, and afterwards I started working in a law firm. But to tell you the truth, it was not so interesting to read all these divorces and all these things. And then I saw an advertisement that the International Committee of the Red Cross looks for delegates. And then I applied there and did the course, and then I was sent. I mean, you have no chance to decide where you want to go to. And then they said, okay, you're needed in Lebanon. And then I had to go to Lebanon. And then I ended up to be there for about 2 years. It was very interesting to see all this. And for us, for my country, coming, which is quite well off, which we never had war for the last 150 or 200 years. Of course, it's quite an experience to see how countries go through such experience of armed conflict, which of course is quite tough, very bad, and but it's nevertheless an interesting personal experience. So therefore, I definitely enjoyed it. It was very interesting, and I'm still thinking of it back every day, and I think it was a very positive experience for me.
And since you think of it as a positive experience, given your legal background by education and practice, and given that you've tried both practicing at a law firm and working in the humanitarian and human rights field, as a legal expert, what do you think the human rights field or the humanitarian law lacks for it to be more trustworthy, more reliant upon? What does humanitarian law lack at this phase or at this point of time?
Well, what is lacking is an international police. If you would have an international police force, which you could say, okay, there's a situation in a country, okay, and now an international police comes. Like in my country, if there's a problem, then we go to the police. But internationally, there's such a police doesn't exist. The UN tries it somehow, but it doesn't work that well. And we also have to say the international, I mean, very often people say these laws are no good. They should be written differently, should be done differently. But we should never forget laws are only accepted by the countries. Countries, of course, only accept laws, international treaties, which are for their benefit and which are not against them. Therefore, the big countries, after the Second World, it was a situation where everybody said, okay, we agree to make the Fourth Geneva Convention and to revise all the Geneva Conventions. Today, I'm sure it would be impossible to make these Geneva Conventions again. It would need a completely different situation, that the countries would be open and say, yeah, we are open to changes. Like the International Criminal Court, the idea was so good and said, okay, wow, if somebody makes any war crimes and so on, then they can put into front of an International Criminal Court, that so on, it's all good. But then the Americans, which were very much involved in it, and at the end they said, yes, it's all good, but this International Criminal Court can never be used against us, because they have their forces all over the world, and the chance that they make violations, of course, is very big. And they said, no, we will not accept that they can do anything against this. So they are now not part of it anymore. The Russians are not part of it. The Chinese are not part of it. The Israelis are not part of it. So many countries are not part of it. That, of course, is unfortunate, but that's the situation which we have to accept. And you as a lawyer must probably understand that it's easy to say ideal laws should be in a certain way, but the reality, of course, is quite different. So here in the Fourth Geneva Convention, or the Fourth Geneva Convention gives protection to civilians. And here, Article 27, they should be treated always humanly, respect for their persons, honor, family rights, religious convictions, and protection against all acts of violence, insult, and public curiosity. So this is a very general article, which is, of course, violated very often, and there shouldn't be any discrimination. So if you say, hey, we have a certain discrimination, then usually you could use this Article 27 of the Fourth Geneva Convention. Then also no physical or moral coercion or torture can be used to obtain information, and pillage is forbidden. So you cannot go into a village and then steal the things from left and right. Collective punishment is forbidden. That's Article 33. And Then something very important is Article 49. Article 49, prohibition of deportation and transfers in both directions. This sounds quite, well, nothing very special, but we should go back historical. This article came in the Second World War, when the Germans, when they occupied the eastern countries, Poland and other countries, they transferred a lot of their own population into those countries. Germans were moved into Germany, into Ukraine. And therefore, in the Fourth Geneva Convention, Article 49 says this is forbidden. And in addition, it says it is a grave violation of the Geneva Convention. A grave violation means it is a war crime. The Geneva Convention doesn't speak of war crimes because they don't use the word war, because war is not used anymore. It's an armed conflict. So they say it's a grave violation and it is a war crime. So for example, the transfer of population into the occupied area of the West Bank, this is a war crime according to Article 49.
So someone might ask right now, what if, let's say, the Israeli government decides to transfer in more Jews from around the world into Israel, and it's considered right now, and it's, well, actually, it's always considered in a time of conflict. I know that Israel is not a signatory to the Geneva Conventions.
No, it is signatory. It is signatory.
Okay, so
it
in
is
this
signatory
case,
of the Geneva Convention, yes, not of the criminal court.
sorry, not of the criminal court, excuse me.
Yeah.
So would this amount to violation, since it always considers itself in a time of war or armed conflict, and what if now it decides to transfer in more Jews or something of that sort? Would this amount to a violation of international humanitarian law?
Yeah, if they go into the occupied area, into the West Bank, yeah. But if they go into Haifa and Tel Aviv, that is not. Into Israel itself, but into the occupied areas, to transfer people into the occupied area, which is considered West Bank or Gaza, that would be a violation. It would be a grave violation, would be a war crime according to Article 49. Then also what is interesting, the occupying power is responsible for public order and safety. That means an occupying power has to look after the safety and everything of that area. So if we now speak quite a lot of UNRWA, of that organization organized by the United Nations after the Second World War, when the Israel-Palestinian conflict started and so many refugees left Israel, went into Lebanon, Syria, Jordan, West Bank, Gaza, Egypt. Then UNRWA was set up. That was by the United Nations, and it was working in that area. And when then Israel occupied the West Bank, Israel was quite happy that UNRWA was there giving all the assistance to those refugees in that area, because otherwise it would be the occupying power which would need to give that assistance, which would need to run the schools, which would need to run sewage and water and all electricity, all these things, which now to a big part is done by the UNRWA in those areas. UNRWA, which is paid by so many countries worldwide. So from that point of view, it's clearly the Israel who wanted and who were quite happy of having this UNRWA, which at this moment now they say it's not so good. So the penal law of occupied territory continues to be in form, except where it will be a threat to the occupying power. This is also something, a quite interesting thing. When Israel was occupying the West Bank, or there was still a law in force from the English, from the British, when they were in that area. When the British were in that area in the 20s and 30s, they put up, and there was quite a fight between the local population against the British, and the British then made a law which says if somebody attacks a British soldier or does something against a British soldier, then this person can be detained, and the house where he lives or is supported from can be destroyed. So the Israelis are using that article and say, okay, when there's a suicide attack happening, then we go back and check in which house he was living or he was supported from. And then according to the law, to the article, which is still from the British in that area, we have the right to destroy that house. So this is going back to the British. So here we have a summary of grave violations, which is willful killing, torture, inhuman treatment, biological experiments, willful causing great suffering, compelling persons to serve in the forces of the hostile power, willful depriving of a power of a prisoner of war depriving a prisoner of war of a fair trial. These are grave violations according to the third and also according to the fourth Geneva Convention. The fourth Geneva Convention also puts that as a grave violation.
So,
and it also mentions then,
the question in international humanitarian law is always, what's the line or where's the criteria? Because some things are always left too vague in the field of human rights, international humanitarian law, to the point where it's very argumentative. So what determines a hostile power and when you are compelling people to serve in the forces of a hostile power? What perspective are we looking at it from? If we were to look at it from the perspective of the law itself, how does the law look at it?
Okay, that this, for example, is the case where they say, okay, we take now some local population or soldiers, and we force them that they have to fight for us. We put them at the first borderline where fighting is taking place, and then they are more or less cannon fodder. And that would be a clear violation, would be a clear grave violation, would be a war crime. And here, of course, there are plenty of questions you would have. The Geneva Convention itself, of course, are very simple articles, but very important if you are interested in it. There is also the commentaries to each Geneva Convention has a commentary of about 500, 1,000 pages, which explains how that article was formed and how it should be applied. So if you are considering working, for example, for the International Committee of the Red Cross and so, it's good if you make perhaps yourself a little bit familiar and know, there is a commentary which can help which would help to understand the situation better. Then also, an important thing is that the first article of the Geneva Convention says that the parties, I mean the countries, there's 196 countries to the Geneva Convention, they undertake to respect and to ensure respect for the present convention in all circumstances. So that means they will follow the Geneva Convention, and they will also see that the Geneva Conventions are respected well in a country where a war is taking place. So if they afterwards see that a person has made war crimes and nothing was done against him, and this person happens to live in their country or travel through their airport, they have the opportunity and the commitment or the task to detain such a person and investigate the matter. So this is also a duty of all the other countries. But of course, you can imagine that many countries, for example, in concerning Belgium, in 2002 or 3, Belgium became quite tough, and they said, hey, okay, there were several war crimes which have taken place in the West Bank, in Gaza, and they said, okay, these were done by certain Israeli soldiers or colonels who have given the order, and they wanted to detain those people in Belgium. It was announced, hey, if they travel through Belgium, they will be detained. But then afterwards, such a pressure was put on Belgium by several countries, by the Americans, by European countries to stop this practice. So they stopped it. So that is shows, of course, bigger countries have bigger force. Yeah.
Urs, would you like us to see if any of the attendees would like to ask any questions or make any comments
Yeah,
before,
please feel
before we try
everybody
to
should bring up
wrap this up?
questions. Yeah.
Because even though if it's an interview and I'm the host and you are our very dear and special guest, but everyone's permitted to talk in today's interview, so feel free to raise your hands or to ask the questions right away.
Yeah, please.
In the meantime, I would like to ask you, Urs, we had a question about how we can be involved with the International Committee and with the Red Cross. However, if I'm a lawyer who's interested in the human rights, interested in the humanitarian field, and okay, so we have a question. Would it be advisable for Arab countries to follow Belgium in their practice to put more pressure on Israel, at least to stop violations? So what's your take on that? What's your opinion?
Well, according to what they have signed, and all these 196 countries have signed these Geneva Conventions, so they should do it. And I think it would be good if the people, population, or part of certain parties in those countries would remind their government about their duties. And not just to say, okay, war crimes have happened, this is forbidden, human rights have been violated, but to go and speak with the people and say, hey, according to Article 1 of the 4th Geneva Convention, it's the responsibility of our country, I mean, of Switzerland, of Germany, of Canada, to do something against those countries which have made violations, to go physically up. I definitely would recommend to do that, but unfortunately, very few will do it.
Exactly. In this case, and as you mentioned earlier, and also following up on one of the previous questions that were asked today regarding the reports that the International Committee or other organizations direct towards the governments directly or put before the governments, they are kept confidential, correct?
The reports of the ICRC to the government are, yeah, they are private. They are not public.
In this case, let's suppose, as we might expect, that the governments or any parties taking part in armed conflict do not abide by the reports, do not abide by the recommendations. Do the International Committee have the right to go public with these reports or to take them to the press, to publish them to the public opinion, at least for them to prove to the public opinion that they have kept their part and they have maintained their role as an international humanitarian organization?
Well, the duty of the International Committee of the Red Cross is not to go public. The duty of the International Committee of the Red Cross is to work with the parties of the Geneva Convention, those 196 countries, to make them aware of violations. But to go public wouldn't help. If, for example, if they would go public, then definitely they wouldn't be able to visit any any detainees and to be effective. So I think that is quite well how it is done. The ICRC has this duty, but other organizations like Amnesty International and many human rights organizations, they go public. I think that is quite good, but they don't see visitors. They cannot visit prisoners. And the International Committee of the Red Cross, they can go and see prisoners. So I think that is, I think it's would not be wise to mix that up.
Okay, and if we were to have your final remarks on what we need to do as lawyers, as practitioners, to take part in advocating for human rights and international humanitarian law, what would your recommendations be? And I would add to that another question from Mr. Ahmed Al-Nagar. Does the Geneva Convention speak about the rights of free journalism and protection to press?
Well, it doesn't mention directly the journalists. It doesn't mention them directly. And journalists are civilians, so they should be treated as any civilian. But, which of course also should be mentioned, if you as a journalist go in the middle where some fighting is taking place, this is a risky area. that, of course, we should be aware of. It is a little bit difficult that if a journalist goes in the middle of some shooting and say, hey, I'm a journalist, I can report, I can make a nice film of it, I can make selfies with it. But of course, you cannot shoot at me, which they shouldn't, but something can happen. So here, I wouldn't go too much that there should be a special law to give protection to journalists. They are protected as any other civilian. But of course, what we see, what has happened in Gaza, of course, is completely clear violations, and that so many journalists have been killed, that definitely will be violations. Yeah.
And the repetitive pattern might show us the deliberate attack and the willful attack against press and against journalists, and probably for different intentions. But when it becomes repetitive in a certain pattern, it becomes more of a deliberate and willful attack against this specific group of civilians. So
yeah,
again,
that definitely is a clear violation and should be stopped. But I wouldn't put now a special law just for them. The general law is there. Civilians have to be protected. And of course, as we can see, these are violated left and right as well. So I wouldn't go too much into details now for special professions.
And as I asked before, like, what would your final remarks and recommendations be for legal practitioners to advocate for international humanitarian law and human rights, especially that you being one of them, moved from private practice and the work in law firms to dedicate years of your life in such critical time, in times of conflict and war and times of occupation for this humanitarian field? What would your recommendations be?
Well, I would recommend anybody who has a certain interest in such in this law field to be open and to contact as many organizations as possible. The International Committee of the Red Cross, which is 160 years old, 170 years old, is definitely a very leading organization. Usually you don't spend your whole life with them. Perhaps you work 3, 4, 5 years with them, and then perhaps you start working with the United Nations, or you go back in a normal legal field. But definitely I think it would be a good thing to do. And as we can see, for the next few years and decades, it's not something which will disappear. Unfortunately, there will be more wars, and all the time, as we can see in Africa, plenty of them are going on.
I know it's late your time now, and I know these were supposed to be your final remarks. However, we have one last question, which goes as follows from Noor. Noor is asking, concerning the Lebanese-Israeli conflict, how would the international humanitarian law apply, given that this conflict has not been classified as an international dispute?
What do you mean it has not been classified as an international dispute? Of course it is. It is an international armed conflict between one country and to the others. So that definitely will mean that it is violations are taking place, and these are violations of the Geneva Conventions. I wouldn't call them now, it doesn't apply.
So the international humanitarian law must apply, and accountability must take place in the correct order.
Yeah, definitely. Yeah.
I wonder if we have any more questions about that, or if Noor would like to follow up on her question to get more clarification if it was not adequately answered. If not, I would like to thank Urs for his time. I know he probably had more slides to tackle, to show us. However, I tried to keep and maintain the interview format with Urs and have this fruitful discussion, make sure we benefit from all his experience and all the years he spent in Lebanon. Urs, even though he spent very little years, he speaks Arabic very well, and I'm sure he has maintained a lot of his Arabic.
Yeah, but at least if you give me the chance to speak a little bit Arabic. أنا اسمي أورس، أنا من سويسرا، أنا محامي، أنا سكون في سور في لبنان. أنا شغل هناك في 84 و 85. أنا شغل أيضا في أنصار في نباتية. شكرا كتير. And مع السلامة يا شوفك بعدين.
That's impressive, Urs. Can you do more, or is it
These are
just that?
these words I know very well, but if you would have asked me something, I wouldn't understand one word. Yeah.
Thank you so much, Urs. It was a pleasure having you. I thank you for all that you presented, for your time. I know it's late now for you. I would like to thank all the attendees for their time as well. We will definitely keep on going with our laws of war interviews to get more ideas, more insights from legal practitioners, experts in international policy, and probably dive deeper into other wars and armed conflicts around the world, and know more about what happened there, either historically or what's happening at the moment. Thank you, everyone, for your participation. And again, thank you, Urs, and good night.
Thanks a lot. It's really nice and I enjoyed it. Thanks a lot. Thank you. Bye-bye.
Until next week. Bye-bye.
Thank you. Bye-bye.